In the quiet hum of data centers, a new intelligence is awakening. Across the globe, artificial intelligence is reshaping industries, sparking revolutions, and challenging our very understanding of creativity. This unprecedented technological surge, spearheaded by giants like NVIDIA, promises a future brimming with possibilities, yet, beneath the surface of innovation, a storm is brewing, threatening to redefine the boundaries of ownership and originality in the digital age. For decades, NVIDIA has been synonymous with powerful graphics processing units, fueling the most demanding video games and intricate visual effects. But in the last decade, their technology became the backbone of a far grander ambition: artificial intelligence. Their GPUs, originally designed for rendering pixels, proved perfectly suited for the complex computations required to train vast neural networks, positioning NVIDIA at the very epicenter of the AI revolution. At the forefront of this revolution lies generative AI, systems capable of creating original content, images, music, and critically, text. These AI models don't just process information, they learn patterns, styles, and nuances from immense datasets, then generate entirely new works that can mimic human creativity with astonishing accuracy. It's a technology that promises to unlock unprecedented creative potential, democratizing creation itself. But for AI to learn, it needs fuel. That fuel is data, unimaginable quantities of it. Billions of images, millions of hours of audio, and countless texts, all fed into algorithms to teach them everything from recognizing a cat to writing a sonnet. The larger and more diverse the dataset, the more sophisticated and capable the AI becomes. It's a relentless hunger for information, consuming the digital world whole. As generative AI began to produce increasingly sophisticated outputs, a new kind of question emerged: where did this knowledge come from? Whose creations formed the foundation of these new digital artists and writers? For many, the answer felt unsettlingly clear. It seemed that AI was learning from, and in some cases reproducing, the very works of human creators, often without their knowledge or consent. Then, the whispers turned into a roar. A collective of authors, deeply concerned about the unauthorized use of their life's work, decided to act. They alleged that their copyrighted books had been ingested, analyzed, and used to train NVIDIA's powerful AI models, effectively transforming their intellectual property into raw material for a new technological frontier, without compensation or attribution. This wasn't just about mimicry, it was about appropriation. These plaintiffs weren't just individuals, they represented the very backbone of creative industries. Writers, novelists, poets, individuals whose livelihoods depend on the value and protection of their intellectual creations. Their motivations were clear: to defend the sanctity of copyright, to ensure fair compensation for artists, and to prevent a future where technological advancement comes at the expense of human artistry. They stood as guardians of the written word. At its heart, the lawsuit alleges direct copyright infringement. The core claim is that by using copyrighted books to train its AI, NVIDIA essentially made unauthorized copies of these works. While not direct reproduction in the traditional sense, the argument posits that the very act of ingesting and processing these texts to derive patterns constitutes a form of copying that falls under copyright protection, especially when these patterns are then used to generate new, derivative works. The allegation specifically pointed to a vast array of copyrighted books, ranging from contemporary bestsellers to timeless literary classics. These were not obscure texts, they were works readily available, widely read, and critically protected by law. The sheer volume and commercial value of these alleged source materials underscore the magnitude of the claim, suggesting that a significant portion of NVIDIA's AI knowledge was built upon a foundation of uncompensated creativity. To understand the allegations, one must grasp how AI models learn. They don't read it in the human sense. Instead, they ingest text as data, breaking it down into tokens, identifying statistical relationships, grammar, style, and semantic meaning. This process, known as pattern recognition, allows the AI to develop an internal representation of language. It's an incredibly complex feat of engineering, but it necessitates the initial copying of the training data into the system's memory. NVIDIA's defense hinges primarily on the principle of fair use. This cornerstone of copyright law allows limited use of copyrighted material without permission for purposes such as criticism, commentary, news reporting, teaching, scholarship, or research. NVIDIA would likely argue that training an AI model falls under these transformative uses, asserting that the AI doesn't reproduce the original work but rather learns from it to generate something entirely new. The central legal battle will likely revolve around whether AI training constitutes transformation or reproduction. If the AI merely reproduces or creates derivative works too similar to the original, it's infringement. But if the AI truly transforms the original content into something new, distinct, and serving a different purpose, it could be deemed fair use. This distinction is subtle, complex, and will likely require the court to grapple with the very nature of AI creativity. For authors, the stakes are profoundly personal. The unauthorized use of their work to train AI models represents a significant loss of control over their intellectual property. It bypasses established licensing frameworks, undermining their ability to earn a living from their creations. Moreover, it raises existential questions about the value of human artistry when AI can generate content that competes with, or even replaces, their output without compensation. For NVIDIA, the stakes are equally monumental. A ruling against them could lead to substantial damages, potentially amounting to billions in compensation to copyright holders. Beyond the financial impact, their reputation as an AI leader could be severely tarnished, potentially setting a precedent that stifles AI innovation across the industry. The future direction of their AI strategy, and indeed the entire generative AI landscape, hangs in the balance. The courtroom becomes a battlefield where legal precedent meets technological frontier. Judges and juries, accustomed to traditional forms of copyright infringement, must now navigate the intricacies of neural networks, machine learning, and the abstract nature of artists' understanding. It's a clash between established legal principles and rapidly evolving technology, where every ruling could set a powerful precedent for decades to come. As with any complex litigation, the initial stages involve extensive legal maneuvering. Motions to dismiss, discovery of evidence, and expert witness testimonies become critical. Both sides meticulously build their cases, scrutinizing data, algorithms, and legal interpretations. These early skirmishes often set the tone for the entire legal process, determining which arguments will be heard and which evidence will be admissible in the court of law. Crucial to bridging the divide between legal principles and technological realities are expert witnesses. Computer scientists, AI ethicists, and copyright scholars are called upon to explain the complexities of AI training, the nature of creativity, and the intent behind copyright law. Their testimony can sway a court, making abstract concepts tangible and helping judges and juries understand the profound implications of their decisions. NVIDIA's broader argument likely champions innovation and technological progress. They might assert that restricting AI training based on current copyright interpretations would stifle development, hindering advancements that could benefit humanity in countless ways, from medical research to education. They could frame their data acquisition as a necessary step for machine learning, distinct from human-authored derivative works. Conversely, the authors argue for the paramount importance of protecting human creativity. They contend that without robust copyright protections, the incentive for artists to create diminishes, leading to a barren cultural landscape. Their stance emphasizes that fair compensation and control over their work are fundamental rights, and that technological advancement should not come at the cost of disempowering the very creators it purports to emulate. This lawsuit highlights a critical vacuum in legal frameworks. Current copyright laws, largely drafted in an era before pervasive digital networks and certainly before advanced AI, struggle to adequately address the complexities of AI training data. There's a distinct feeling of a digital Wild West, where rapid technological advancement has outpaced the legislative and judicial systems, leaving both creators and developers in a state of uncertainty. Whatever the outcome, this case is destined to be precedent-setting. A ruling in favor of the authors could force AI developers to rethink their data acquisition strategies, potentially requiring licenses for training data. A ruling favoring NVIDIA could solidify the fair use defense for AI, opening the floodgates for more widespread data ingestion. Either way, the verdict will ripple through the entire AI industry and the creative economy globally. As of now, the legal process is unfolding, with preliminary motions and arguments being heard. The court is carefully weighing the intricate legal and technological aspects. There hasn't been a final verdict on the core copyright infringement claims. However, early procedural decisions on motions to dismiss or for summary judgment are closely watched, as they indicate the court's initial leanings and the strength of each side's arguments. For AI developers, the case represents a moment of reckoning. If the court leans towards stricter copyright interpretation, companies might need to invest significantly in licensing agreements for their training data. This could create new revenue streams for creators but also raise the cost and complexity of AI development. It pushes developers to consider ethical sourcing of data not just as a best practice, but as a legal imperative. For authors, the outcome could either usher in a new era of digital rights protection or condemn them to a perpetual struggle against technological appropriation. A favorable ruling would empower them to negotiate fair terms for the use of their work in AI training. Conversely, a loss could leave them vulnerable, with their creative output fueling algorithms without their consent or compensation, potentially devaluing their entire profession. The future trajectory of generative AI itself is on trial. Will it be constrained by stricter regulations, forcing it to develop within more clearly defined ethical and legal boundaries? Or will it be unleashed, its development accelerating, but at the potential cost of intellectual property rights? The answer could profoundly shape the types of AI we see, the content it generates, and its integration into our daily lives. This lawsuit epitomizes the delicate balancing act between fostering innovation and protecting individual rights. Society craves technological advancement, but not at the expense of fundamental human values like intellectual property. The court's challenge is to find a middle ground that allows AI to flourish while ensuring creators are recognized, compensated, and retain control over their original contributions to culture and knowledge. NVIDIA's case is not isolated. Across the globe, similar lawsuits are emerging, reflecting a universal struggle to adapt existing laws to unprecedented technological capabilities. From artists suing image-generating AIs to musicians challenging sound-alike algorithms, the legal landscape is fraught with challenges. This collective global effort underscores the urgent need for harmonized international standards to govern AI and intellectual property. The problem is compounded by the accelerating pace of technological advancement. By the time a lawsuit concludes, AI capabilities may have leaped years ahead, rendering previous legal interpretations potentially obsolete. This constant evolution demands a legal system that is not only reactive but also proactive, capable of anticipating future challenges and establishing flexible, robust frameworks that can withstand rapid change. Beyond the purely legal arguments, the case raises profound ethical considerations. What constitutes fair use in the age of AI? How do we ensure algorithmic transparency and accountability? Should AI models be required to disclose their training data sources? These are questions that extend beyond the courtroom, impacting public trust, industry standards, and the very moral compass guiding AI's development. At the core of this impersonal legal battle are deeply personal stories. The authors are not just legal entities, they are individuals who pour their souls into their work, dedicating years to crafting narratives that move, educate, and inspire. Their fight is a poignant reminder that while AI can mimic, it is human experience, emotion, and intellect that truly originate the creative spark. Their words deserve respect and protection. NVIDIA envisions a world radically transformed by AI, where intelligent machines assist us in every facet of life, accelerating scientific discovery and enhancing human potential. They see this lawsuit as a potential obstacle to that vision, arguing that an overly restrictive interpretation of copyright could stunt the growth of a technology poised to solve some of humanity's greatest challenges. For them, the stakes are nothing less than the future itself. Irrespective of the NVIDIA verdict, the case amplifies the urgent call for comprehensive regulation and a new legal framework specifically tailored for AI. Many legal scholars and policymakers argue that piecemeal litigation is insufficient. What's needed is a proactive, well-thought-out legislative approach that provides clarity for developers, safeguards for creators, and establishes ethical guardrails for the entire AI ecosystem. The law, often seen as slow to adapt, now holds immense power to shape the very trajectory of artificial intelligence. Its decisions will define whether AI becomes a collaborative tool, respecting and compensating human ingenuity, or an extractive force, consuming existing works to generate new ones without consent. This is more than a corporate dispute, it's a societal choice about the kind of digital future we wish to build. As the NVIDIA AI copyright lawsuit unfolds, the path ahead remains shrouded in uncertainty. Legal teams on both sides continue their meticulous work, preparing for the arduous journey through the courts. The world watches, waiting for a definitive answer that could fundamentally alter the landscape of technology, creativity, and intellectual property. The only certainty is that the implications will be far-reaching, regardless of the ultimate verdict. Ultimately, this lawsuit forces us to confront an ancient question in a brand new context: who owns creativity in the age of artificial intelligence? Is it the human artist who poured their soul into a masterpiece, or the algorithm that learned from countless such works to generate something new? The resolution of this case will not only determine NVIDIA's fate but will profoundly influence the definition of ownership and originality for generations to come. This is a pivotal moment in the history of technology and law. The decisions made in courts today, the arguments carefully crafted by legal minds, and the very interpretation of ancient statutes in a new digital age, will lay the foundation for how humanity interacts with its most powerful creation yet. It's a testament to the enduring human spirit of creation and the complex challenges that arise when innovation pushes the boundaries of what's possible. The road ahead is long, filled with intricate legal arguments and technological nuances. But at its core, this case is about redefining value, the value of human creation, the value of data, and the value of the intelligence that emerges from it. As NVIDIA and authors stand poised in this legal battle, the outcome will echo far beyond the courtroom, shaping the very ecosystem of creativity and innovation for decades to come. The pursuit of innovation often clashes with the pursuit of justice. NVIDIA's AI lawsuit is a dramatic stage where these two powerful forces collide. The legacy of this case will be written not just in legal tomes, but in the future development of AI, in the economic viability of creative professions, and in the global understanding of what it truly means to own a piece of human ingenuity in an increasingly automated world. A future waits to be defined. Ultimately, the future of AI and creative rights isn't solely in the hands of judges or corporate executives. It's a shared responsibility for technologists to build ethically, for legislators to adapt laws proactively, and for creators to advocate for their invaluable contributions. Only through collaboration and a deep understanding of mutual interests can we navigate this complex new landscape and build a digital future that truly benefits all. The NVIDIA AI lawsuit is an unwritten chapter in the ongoing saga of human progress. Its pages are being inked in courtrooms and corporate boardrooms, in research labs and artist studios. The story is far from over, but its beginning has already ignited a global conversation that will shape the very essence of what we call the creation and ownership for generations to come. The future is watching, waiting for its next line.